Module tag FSC P1 M27 Learning Outcome. After studying this module, you shall be able to know about the general rules of acceptance of testimony, the Fry and Daubert's rule of acceptance, overall impact of Daubert Standard. Introduction. Forensic science deals with collecting evidence, analyzing them in the laboratory, making report and presenting it as a testimony in the court of law. But to perform all this, the forensic scientist has to follow certain rules to give an expert opinion on any forensic evidence to make the testimony admissible in the court of law. With continuous progress made by the science, the need was felt to frame and standardize certain norms which may set criteria to accept opinion based on scientific analysis by the court of law. In US, currently 3 major sources guide the admissibility of evidence and who can serve as an expert witness in the court of law. These parameters were standardized at first by the Supreme Court of US in 1993 in a case Daubert versus Merrill Doe Pharmaceutical Inc. Before this decision, the Fry General Acceptance Test and the federal rules of evidence were followed by the expert and the courts. The 3 major sources that guide the admissibility of evidence are the Fry Standard, the Federal Rules 702 of Evidence, the Daubert Standard. Now we will be discussing all these in detail.
In 1923, the first attempt has been made in US to develop a coherent test for the admissibility of scientific evidence in the court of law by issuing a landmark judgment in a case of Fry versus United States 293 F 1013. The Columbia US District Court rejected the scientific validity of the lie detector test because the technology did not have significant general acceptance at that time. This federal case has been decided by the District of Columbia Circuit in 1923 judgment. In Fry case, considered the admissibility of testimony which was based on the systolic blood pressure test and was a precursor to the modern polygraph test. The court declared that a novel scientific technique must be sufficiently established to gain general acceptance in the relevant scientific field to which it belongs. Thus, under the standard set by Fry's, it is not enough that an expert or experts are qualified individual to testify that particular technique is valid, but the special requirement of Fry standard was that particular scientific evidence is allowed in the courtroom only if it is generally accepted by the relevant scientific community. Now, let me tell you something about the Federal Rules 702 of Evidence. In 1975, after Fry, the US Federal Rules of Scientific Evidence were promulgated to guide criminal and civil litigation in the federal courts. The first version of Federal Rule of Evidence was framed as if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in the issue, then a witness qualified as an expert by knowledge, education or training, skill and experience may testify thereto in the form of an opinion or otherwise. After the promulgation of Rule 702, litigants, judges and legal scholars remain at odds over whether the rule embraced the Fry standard or established a new standard. There was also much controversy in the application of Rule 702 of evidence in civil cases, such as judiciary's acceptance of unreliable expert testimony in support of tort claims. The Fry's test or general acceptance test was deduced from the rejection of testimony in a case in which the lie detector was used. It was based on the assumption that the conclusions to be made admissible in the courts should be based on the scientific principles which must have gained general acceptance from peers in that particular field. The reason for this assumption was to avert the admittance of evidences, and the observations deduced from such evidences are based on fallacious and uncorroborated scientific principles. Then, in 1975, the Federal Rule of Evidence, which was more liberal in approach and states as, if scientific, technical or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training or education may testify thereto in the form of an opinion, or otherwise if the testimony is based upon sufficient facts or data. The testimony is the product of reliable principles and scientific methods. Lastly, the witness has applied the principles and methods reliably to the facts of the cases. The motive of framing this rule was to elucidate the capability of the experts to choose the adequate fact, reliable methods and their proper applications in that particular field while forming an expert's opinion. Now, dear students, let me tell you about Daubert Standard. In 1993, the ruling of US Supreme Court in case of Daubert versus Merrill Dow Pharmaceuticals, which is also known as the Daubert ruling, provided a detailed framework to help the judge to determine the relevancy and reliability of evidences which are to be produced in the court by the experts. In this case, two children born with serious birth defects and alleged that Benedictine, an anti-nausea drug used by pregnant women, claimed to contain a combination of dicycloamine hydrochloride and dioxylamine succinate, which is tetragonic, has caused the birth defect. Merrill Dow's experts submitted documents showing that no published scientific study demonstrated a link between Benedictine and birth defects. On the contrary, plaintiffs were failed to produce evidences which could suggest that Benedictine causes birth defects, as their methodologies had not yet gained acceptance within the general scientific community at that time. As a result, the Supreme Court outlined some rulings which must be followed by the experts in order to produce the expert testimony in the court of law. Those rulings were the empirical testability of a particular scientific theory or a technique. The study or theory has been subjected to peer review or published. The acceptance of known or potential rate of errors of theory or technique, and the existence and maintenance of standards. And lastly, the general acceptance of theory or technique in the scientific community. The Daubert Court also observed that concerns over shaky evidence could be handled through rigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof. In many states, scientific expert testimony is now subject to this Daubert standard, but some states still use a modification of the Fry standard. Now, let us discuss influence of Daubert standard on forensic science. Now, Daubert's decision wholly transformed the way through which the expert testimonies have been inspected by the courts. The evidences were reassessed either to accept or reject. In Daubert, the trial judges responsible to act as gatekeepers to exclude unreliable expert testimony. And the court in Kumho clarified that this gatekeeper function applicable to all expert testimony, not testimony just based on science. So, applications of some of the Daubert's factor degraded the admissibility of non-scientific expert testimonies based on fingerprint analysis, handwriting analysis, etc., as the analysis involved with these evidence is highly subjective. Now, let us see the impact on fingerprints with respect of Daubert Standard. The admissibility of fingerprints as a scientific evidence falls in controversial situation after Daubert's ruling. In 1999, the first challenge to fingerprint evidence took place in United States versus Byron Mitchell in Eastern District of Pennsylvania. In this case, District Court admitted the fingerprint evidence considering the ruling testimony to be reliable. In 2004, the Third Circuit Court of Appeals stated that fingerprint identification fulfills the standard for reliability established in Daubert and Kumho cases. In another case, United States versus Laurel Plaza, the ACEV method of fingerprint identification was only partially admissible as the method was failed to fulfill the following parameters of Daubert ruling. Number 1, impossibility of accurate peer review due to non-alienation of fingerprints to any particular scientific community. Testability element as the analysis which is subjective in nature varying within the fingerprint expert community. Thirdly, insufficient harmony regarding obligating the exact number of points between two fingerprints to be matched before considering final match. And lastly, inadequate control standards, I repeat, and lastly, inadequate control standards in context to specific qualifications or certifications mandatory to be a fingerprint expert. While presenting testimony in the court, the fingerprint experts need to explain the methodology used in taking fingerprints and or in developing the latent prints to show the enlargement of prints depicting ridges, minute details and points of similarity and dissimilarities between the given prints. The fingerprint experts all around the world are now working to prove the scientific basis of this crucial evidence, which is the permanency and uniqueness of all areas of skin established after hundreds of years of research. Now let us discuss DNA after Daubert. The characteristics of DNA such as its polymorphism, durability, reliability, reproducibility and its uniqueness make it significant scientific evidence in crime investigation and help in solving the paternity cases. DNA matching has already overcome the necessity of blood typing used for identification purposes. The first criminal case in which DNA has been used as one of the deciding evidence was Andrews versus State occurred in US. In India, Kunhi Raman versus Manoj 2 was the first parentage dispute case that was solved on the basis of DNA fingerprinting. In 1991, a disputed paternity was settled using DNA fingerprinting. Some of the following cases in India where DNA fingerprinting has been used to identify the person like Rajiv Gandhi assassination case, Ben Singh assassination case decided on 11th May 1999, Naina Sahni case, Priyadarshini Matto murder case, N.D. Tiwari case, the black bug poaching case of Jodhpur were the important ones. In India, 3,276 judgments from the various high courts and the Supreme Court of India related to DNA and DNA tests are available both in criminal and civil cases till 7 December 2015. DNA evidence has been challenged on various grounds. such as inadequate lab accreditation, contamination, lack of quality control, improper techniques, broken chain of custody, and use of statics while presenting it as a scientific evidence in the various courts of US and other countries. The scientific community is working to resolve all these issues related to this very crucial evidence, as it is vital evidence in depicting the presence or absence of particular person at the crime scene. Now let us have a look on Indian legal system. Most of the times the admissibility of scientific evidence in Indian courts do not face as such any problem, but the Daubert rulings can be implemented if any doubt persists. To elude any inconsistency in the courts, the standard and quality control for scientific evidence are not standardized yet. Now let us have a look on section 45 of Indian Evidence Act. It deals with the opinion of the expert relating to the expert testimony to be presented in the court. It states when the court has to form an opinion upon a point of foreign law or of science or art, or as to identity of handwriting or fingerprint impression, the opinions upon that point of persons specially skilled in such foreign law, science or art, or in questions as to the identity of handwriting or fingerprint impressions are relevant facts. Now let us see section 293 of the Code of Criminal Procedure. It deals with reports of certain government scientific experts. Section 293(2) says that the court may, if it thinks fit, summon and examine any such expert as to the subject matter of his report. Now let us have a look on law supervising fingerprint evidences. As per section 3 of Indian Prisoners Act 1920, the investigating officers is authorized to take the fingerprints of any person who has been convicted with any offence punishable with rigorous imprisonment for a term of 1 year or upwards, or of any offence which render him liable to enhanced punishment on a subsequent conviction. Under section 4, the investigating officers are empowered to take the fingerprints of non-convicted person who have been arrested in connection with an offence punishable for a term of 1 year or more. Now let me tell you something about law guiding DNA evidence. 2 new sections are added in the CRPC Act 2005, which permits the investigating officer along with medical practitioner to collect DNA sample from the victim and accused person's body along with medical examination of both the persons in rape cases. In the cases of disputed paternity, section 112 of the Indian Evidence Act is followed, in which child's parentage is ascertained and unless proved otherwise, but again no specific provision which would cover modern scientific techniques. DNA analysis is of utmost importance in determining the paternity of a child in the case of civil disputes. In the Indian Constitution has given some rights to the people of India, and out of which the right against self-incrimination under Article 20 Section 3 and right to privacy under Article 21 has been challenged by the introduction of the DNA technology on the various grounds. Due to this reason, sometimes some of our courts are disinclined towards admissibility of such evidences, but both of these rights can be subjected to restrictions by the Supreme Court in its various decisions. That the forensic scientist has to follow certain rules to give expert opinion on any forensic evidence to make the testimony admissible in the court of law. We have also learned that in US currently 3 major sources guide the admissibility of evidence and who can serve as an expert witness in the court of law. These parameters were standardized at first by the Supreme Court of US in 1993 in the case Daubert versus Merrill Doe Pharmaceuticals. Then we have come to know in a case of Fry versus United States 293F 1013, the Columbia District Court rejected the scientific validity of the lie detector test because the technology did not have significant general acceptance at that time. That the special requirement of Frye Standard was that particular scientific evidence is allowed into the courtroom only if it is generally accepted by the relevant scientific community. And lastly, my dear students, Daubert's decision wholly transformed the way through which the expert testimonies have been inspected by the courts. The evidences were reassessed either to accept or reject. That would be it. Thank you.